Hey, Outdoor Legal Warriors. In this video, I'm going to cover some hidden things you need to look for if you're served with a restraining order in Washington State, and also the difference between a temporary order and a permanent order. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm is defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. And I'm just going to jump right into it. If you get served with a restraining order in Washington State, you have a limited amount of time to act. And actually, they're called protection orders. It's going to say protection order on the paperwork. But when people search and look for help and we all talk about things, we talk about restraining orders. So a restraining order is under RCW 7.105. And how that works is the petitioner goes into the court, just a human who has a problem with the respondent, and says, hey, here's a bunch of stuff that the respondent has done to me, and therefore I want to restrict their freedom. I want an order saying they can't contact me. Give me a temporary restraining order, a TRO. And typically the court is going to issue that temporary order without very much proof at all. It's pretty much just on the petitioner's say so. So the petitioner files a petition, the court looks at it without any notice. It's ex parte, without notice. And then they're going to issue a temporary order in most cases. And then for that order to be effective, it has to be served on the respondent. The respondent has to get a copy of the order and a copy of the petition, which is the claims against them that the petitioner filed, to get the ex parte, the one-sided emergency restraints against the respondent. So now if you're the respondent in this situation, you've got some paperwork and you're probably pretty surprised and pretty upset. And I need you to read the paperwork. And there's going to be some tips and tricks to look for certain things in this particular situation. Now, the first thing you want to do is take a look at the actual order. Does the order restrain you or not? It could be a temporary restraining order that has a court date on it. Come back to a certain court. It'll be at the top of the paper which court on a certain date and a certain time, usually 2 weeks after the original order was issued. And you're getting it later than that, though, obviously, because it's going to take a while to serve you. Come back to that court. So it may actually restrain you. If it does restrain you, look through the restraints. Where does it keep you from going? Does it keep you from being within 1,000 feet of the petitioner, or the petitioner's home, or petitioner's kids and workplace or daycare, all types of stuff? I need you to read it. Or is it a denial order? Did the court take a look and say, I'm going to deny any restraints? And you think, great, it's a denial. Not so great. If you got served with it, that means there's still a hearing that you're going to have to answer to. It'll say, hey, I denied, as the judge, emergency restraints, but we still, respondent, want you to come to court to answer to see if the petitioner should get a permanent order. So I'm jumping around, but what does that permanent order mean? Temporary order means there's only been one side that's been heard. It's been ex parte. That's typically good for 2 weeks. A permanent order doesn't necessarily mean it lasts forever. It means that's an order that's now been issued after a hearing or a respondent had an opportunity to appear and respond. A permanent order could be issued if you default and don't respond. It's after you've had an opportunity to appear and respond. Most permanent orders are good for 1 year. They can be good for 2 years, 5 years, or forever, permanent. But most of them are good for 1 year, but they can be renewed by a petitioner. So the first thing you're doing, respondent, is you're looking at your paperwork and you're going, am I restrained? If so, what are the restraints? When am I coming back to court? What court? Or was it a denial order? I'm not restrained yet. Yay. But yet I still have to come back to court to fight about it. Boo. So that's what you're doing first. Secondarily, you're going to look at the petition. The petition is what the petitioner filed, swearing that you did certain things in the petition that entitled them to ask for the order they either got or didn't get, but there's going to be a hearing on. All right. And so you need to look at each and every claim in the petition. And what I learned recently through a person who called us up is there's one other place to look. I looked at this petition and there was like a potential client called up and I looked at the petition. I said, how could they possibly issue a temporary order against you? Person calling me. There's no claims against you that are actually against the law according to the statute RCW 7.105. Why is there a temporary restraint? And then that person pointed out something I hadn't seen before. If you take a look at the actual temporary order on page 3 of 10, number 7, it says other findings. And in that particular case, apparently the judge had taken additional testimony ex parte with just the petitioner there and sort of helped the petitioner state some things that now made it possible for that petitioner to get an order. So there's additional claims that weren't in the petition that are listed under subsection 7 of the actual temporary order. And that was news to me. I'd never seen that. These are newer forms. And so now I know to look there, and now you know to look there through that case. So I want you to look there just to also address any claims if they happen to be under that subsection 7 of the actual temporary order. But mainly you're just looking at the petition to see what the claims were. I've got a lot of other videos on this station about how to respond to a restraining order, but briefly you need to respond in writing. You need to file something with the court. You need to file it with the court ahead of time whenever your response is, saying why you didn't do it or what they're saying is a lie, that type of stuff. You should do that far enough ahead of the hearing so there's actually a chance for the judge to read it. And then you're also required to serve the petitioner with your response. And that's the second little tip or trick here. I want you to look at the petition, page 3 of 10, subsection 5. In that subsection, it says how the petitioner wants to be served, and it better not be blank. If it's blank, then how can you serve them? But basically, you take a look at that section, and it's going to say how they want to be served, either by address or hopefully by email. If it lists an email, then you're going to be able to have them served by email. But usually you want someone to serve it besides you. Someone over 18 who's not you needs to either serve them personally if there's an address or by email if email is listed. So that's something that I want you to remember to do. So that is a very important tip so you know where to serve them. You've got served with 11 pages of a petition, and people say, how do I serve them? It's buried in there, page 3, subsection 5. I've finally learned to look there so I'm able to actually see how to serve someone. So these are some tips and tricks about where to look in this massive paperwork so you know what to do and what's important if you get served with a temporary restraining order. So I hope you found that useful. If so, please like it, please subscribe. More people need to see this. And more importantly, if you got served with one of these in Washington State and you need some help, feel free to give our office a call. We have different things that we do, different programs that we offer to try to help because it's a scary situation. Hopefully we can listen to what happened, identify a way forward, and we could be there for you. Thank you.